requested to ask all oralists not to speak too fast because the interpreters apparently have a challenge. So if everybody could remember that. Council, if you could just, before you start, just repeat your name again so that we know who is doing the presentation.
It doesn't work.
Monsieur le Président, honorable juge de la Cour africaine des droits de l'homme et des peuples, recevez nos salutations les plus distinguées. Nous sommes Maître Salani et nous venons ici, honorable, prendre la parole encore devant vous pour dénoncer dans le fond toutes les violations dont l'État du Kunta Kinte s'est rendu coupable.
I'm sorry, Council. When it was English, because that's the official language that I'm familiar with, I didn't feel the problem that other people were talking about. Now that I'm having a translation, there is a problem. So I think try and not speak too fast. I know there are time constraints. I can hear the translator here is being left behind, I think. You may go ahead.
Au lieu de crier au loup dans la bergerie, le préalable pour un État qui se réclame être un État de droit aurait été de pouvoir déterminer le statut véritable.
I'm sorry, Council, to interrupt you. I'm sorry. My colleagues suggest that you should not speak too close to the microphone.
Okay.
And that may be one of the problems why the translators are having a challenge.
Okay.
So let's try again.
President, yes. If we could also ask the technicians, the council is quite loud, so if you could modulate the volume, because we are hearing more presentation than the interpretation. So if it could be modulated so that we hear less of her voice and we get the interpretation.
Thank you. You may proceed, Council.
Au lieu de crier au loup dans la bergerie et au terrorisme, le préalable pour un État qui se réclame être un État de droit aurait été de pouvoir déterminer le véritable statut des personnes qui ont fait l'objet d'arrestations sur son territoire. En effet, une analyse claire et simple de cette situation honorable nous a permis de déterminer que loin d'être des terroristes, les personnes arrêtées peuvent se prévaloir du statut de réfugiés. Au terme de l'article 1, 3A de la Convention de l'Organisation de l'Unité africaine sur le terrorisme, l'acte terroriste est entendu comme celui qui viole les lois criminelles d'un État susceptible de porter atteinte à la vie, de causer la destruction de biens publics dans l'intention d'intimider et de troubler l'ordre public.
Maître, excusez-moi, j'avais une question à vous poser. Donc vous êtes en train de dire qu'un réfugié ne peut pas être potentiellement un terroriste? Est-ce qu'un réfugié ne peut pas être un terroriste?
Oh non. Honorable, effectivement, relativement aux différentes conventions qui ressortent de l'Union africaine, un potentiel réfugié, une personne réfugiée, ne peut pas être un terroriste, ou encore un terroriste ne peut pas se prévaloir du statut de réfugié.
En fait, la question que je pose, c'est de savoir, enfin, vous avez peut-être suivi l'actualité récemment, je pense, en Europe et ailleurs, vous vous rendez compte que la question se pose aussi sur des personnes qui viennent de zones de conflit, qui peuvent potentiellement aussi présenter toutes les caractéristiques de personnes ayant des liens avec des activités terroristes. Ce que je veux dire, c'est qu'on peut être réfugié, bien entendu au sens légal du terme, mais aussi peut-être avoir des intentions qui sont tout à fait compatibles avec celles d'un terroriste.
Honorable, merci pour votre observation. Il convient de préciser qu'une personne qui, tout d'abord, pouvait se prévaloir du statut de réfugié, lorsqu'elle commet un crime ou lorsqu'elle commet un acte terroriste, elle perd ce statut-là et désormais endosse le statut de terroriste. Honorable, nous disions donc qu'en l'espèce, les jeunes panthères constituent un groupe dont l'objectif est de réclamer la justice sociale. Leur objectif honorable est de réclamer le respect de la démocratie. En l'espèce encore, les manifestations perpétrées, veuillez nous excuser, au domicile de M. Bobo, le président, ont été effectivement faites dans le but de pouvoir manifester, honorable, l'expression du mécontentement de la population face à l'indifférence du gouvernement quant à leurs conditions de vie précaires. L'intention de ces personnes n'était point d'intimider, et encore moins de troubler l'ordre public. Il serait donc injuste, par conséquent, de les considérer comme des terroristes. En outre, l'article 12...
Is your point, counsel, that in the absence of evidence, because the government, it seems, was not willing to disclose any evidence connecting the group to any organization of terrorists, is your submission that the absence of evidence of such connection is decisive on the question whether this was a group that had connections with terrorists?
Honorable, en référence au rapport factuel, le groupe de jeunes panthères sur le territoire du Malinké et non sur le territoire du Kunta Kinte ont eu à perpétrer des actes de violence au domicile du président Bobo. Honorable, il n'est pas question ici de l'état du Kunta Kinte, du rapport qui existe entre l'état du Kunta Kinte et les différents détenus. Nous sommes d'abord en train d'essayer de déterminer le véritable statut de ces personnes. Et nous continuons pour dire, honorable, qu'en outre, l'article 12, alinéa 3 de la Charte africaine des droits de l'homme et des peuples, honorable, prévoit que toute personne qui fait face à des persécutions au sein de son État a le droit de pouvoir demander et obtenir le statut de réfugié. En l'espèce, honorable, 100 000 personnes ont quitté le Malinké pour trouver refuge au Kunta Kinte et 700 d'entre elles ont été emprisonnées. Honorable, il aurait été du devoir du Kunta Kinte de pouvoir déterminer le statut de ces personnes-là. Et alors, elles auraient su qu'elles ne sont pas des terroristes et bien au contraire des réfugiés. Et ces personnes auraient pu bénéficier de la protection qui est accordée aux personnes réfugiées relativement à la Convention de l'OUA sur les réfugiés aux articles 1 et 2. Honorable, ces arrestations injustes ont été, bien sûr, honorable, ces arrestations injustes ont bien sûr provoqué la méconnaissance par le Kunta Kinte du droit de ces personnes-là à leur liberté et de leur droit à un procès juste et équitable. Honorable relativement à leur droit à la liberté. Le Kunta Kinte...
Counsel, before you proceed, on this movement, the Young Panthers, the ideas they were proposing or they were agitating for appear to go at one of the core values of the African Union, which would end up with an undemocratic and unconstitutional change of government. What would you say to that? That organization was probably also promoting principles which undermine the values of the African Union against an unconstitutional change of government.
Honorable, les jeunes panthères ont perpétré ces actions dans l'objectif de pouvoir exprimer leur mécontentement, de pouvoir exprimer leur opinion, comme le préconise la Charte africaine dans son article 9, alinéa 2. Il était du droit de ces personnes-là de pouvoir, honorable, exiger que l'État puisse leur favoriser, puisse leur offrir de meilleures conditions de vie, et non pas que celui-ci reste indifférent face à leur situation. Honorable, nous continuons pour dire que l'État du Kunta Kinte a méconnu le droit de ces personnes à la liberté. La Commission africaine des droits de l'homme et des peuples a affirmé, dans les affaires Civil Liberties, Organisation contre le Nigeria, et dans les affaires Krishna Achutan pour Aleke Banda contre le Malawi, qu'une détention sans accusation, sans jugement, une inculpation de plusieurs personnes sur une longue période pouvait constituer une violation de l'article 6. En l'espèce, honorable, 700 personnes ont été arrêtées, sans motif légal, mais uniquement sur la base de soupçons qui n'ont jamais été prouvés par l'État du Kunta Kinte. De plus, les victimes ont allégué, honorable, qu'elles ne savaient même pas pour quelle infraction spécifique elles avaient été inculpées. Et pourtant, la Commission africaine des droits de l'homme et des peuples a reconnu dans l'affaire Orelos contre Nigeria que méconnaître le droit à l'information du détenu pouvait constituer une violation de l'article 6 de la Charte africaine. Ainsi, honorable, le Kunta Kinte a privé ces personnes de leur liberté de façon arbitraire. Relativement au droit à un procès juste et équitable, il a encore été méconnu par le Kunta Kinte, bien que garanti par l'article 7 de la Charte africaine des droits de l'homme et des peuples. Honorable, le droit à la présomption d'innocence de ces personnes a été méconnu. Dans l'affaire Annette Pagnol contre le Cameroun, la Commission africaine des droits de l'homme et des peuples a estimé, honorable, que le fait d'inculper une personne, de la détenir, sur la base de simples soupçons que celle-ci serait à l'origine de troubles, était une méconnaissance de son droit à la présomption d'innocence. Et en l'espèce...
Maître, excusez-moi, j'ai une question. Donc vous êtes en train de dire qu'une personne qui, bien sûr, bénéficie de la présomption d'innocence ne peut pas être détenue, même dans l'attente d'un procès ou bien dans l'attente de l'instruction de son dossier, d'une affaire.
Honorable, nous sommes en train de dire que ces jeunes personnes ont été détenues sur la base de simples soupçons, comme il était cas également dans l'affaire Annette Pagnol contre l'État du Cameroun. L'État du Kunta Kinte a plusieurs fois...
Counsel, when you talk about mere suspicion, we understand that because of the establishment of the Young Panthers and their ideas, property was destroyed, people were beheaded, so it was not mere suspicion. How do you explain that?
Honorable, effectivement, au nombre de ces jeunes panthères, lors des manifestations au domicile du président Bobo, des crimes ont été commis et des biens ont été atteints. Mais, honorable, si nous nous inscrivons dans cette logique, nous ne pouvons pas impunément, tout simplement, imputer la responsabilité de ces crimes qui ont été perpétrés par une certaine partie de ce nombre de personnes à tout le groupe. Parce que l'intention première des jeunes panthères était de manifester, était de pouvoir exprimer leur mécontentement. Des incidents sont arrivés lors de ces manifestations. Il serait injuste de pouvoir imputer la responsabilité de ces différentes personnes-là, de ce nombre réduit de personnes-là, à tout un groupe dont les intentions de base étaient absolument honorables, légitimes. Ainsi, si nous voulons nous inscrire dans cette logique, il serait convenable de considérer que ces personnes-là sont des criminels. Honorables, dans ce cas-là, l'État du Kunta Kinte avait tout simplement l'obligation de pouvoir les ramener vers leur état d'origine, afin qu'ils soient jugés par leur législation nationale. L'État du Kunta Kinte n'avait pas le droit de les retenir, et encore moins de les arrêter, veuillez nous excuser, et encore moins de les détenir sur cette longue période. Honorable, le temps est écoulé, alors permettez-nous tout simplement de conclure en disant que le Kunta Kinte a failli à ses obligations. Il a méconnu le droit de ces personnes à la liberté, il a méconnu leur droit à un procès juste et équitable en méconnaissant leur droit à la présomption d'innocence, leur droit à être jugé dans un délai raisonnable, ainsi que leur droit honorable à être jugé par un tribunal compétent. De plus, le Kunta Kinte a conservé ces personnes-là, les a détenus dans des conditions précaires, dans des conditions attentatoires. Honorables, la conséquence a été la violation de leur droit à la santé et la violation de leur droit à la vie également. Ainsi, le Kunta Kinte a failli à ses obligations internationales.
Thank you, Counsel. As you start, Counsel, once again, just announce your name again.
Good morning, Honourable Justices. My name is Muzuli Rakivani. This morning, I'll be addressing the Court on the invalidity of the Respondent State's denial of the non-registration of Nugal. I will address this invalidity on 3 grounds. The first, the incorrect assertion that the Constitution of Kunta Kinte does not recognize homosexuals. The second, on the unlawful reliance of the respondent state of the morality of the majority. And thirdly, the applicant will challenge the validity of Article 246 of the COOA of the Constitution of Kunta Kinte. Before dealing with these 3 matters, the applicant will ask that the Court, in the course of these proceedings, keep the following 2 statements in consideration. Firstly, that at no stage will the applicant be asking that the Court strenuously confer new sets of rights, but rather that the Court fulfill its mandate to protect rights already protected in the Charter, the ICCPR, and other relevant instruments. Secondly, the non-registration of Nugal limits the members' rights to association, information, and assembly. Now, the applicants contend strongly that the registration of the Nugal is an important conglomerate in the full exercise of these 3 rights. In order to demonstrate this point, the applicants would refer the Court to the Coalition of African Lesbians and their observation status by the Commission. Now, before the granting of their observation status in front of the Commission, they were freely exercising their rights to expression. However, it's only once they were granted observation status that they were granted certain privileges, such as the ability to make presentations in closed sessions to the Commission based on issues that affect them. In the same way, without the registration of Nugal, they are able to freely associate amongst each other. However, that recognition or registration will allow them certain advantages and responsibilities in front of something like the Parliament of Kunta Kinte in order for them to effectively lobby for the rights of the people, the homosexuals of Kunta Kinte. In dealing with my first submission, I'd like to stress to the Court that it is important that we establish that homosexuals are in fact recognized in the Constitution of Kunta Kinte, because without this, then this group is lobbying for a people that do not exist and therefore whose rights do not need to be protected. Now, on that ground, it is factually incorrect for the Registrar of Societies to have stated that the Constitution of Kunta Kinte does not recognize homosexuals. And the basis of this is that Chapter 2 of the Constitution of Kunta Kinte expressly states that it recognizes all rights contained inter alia Article 16 of the ICCPR, which states that everyone shall have the right to recognition as a person before the law. More so, this can be further demonstrated in the High Court decision of Romache versus the Attorney General of Botswana, which had similar facts and similar principles in law. Now, Section 3 of the Constitution of Botswana states that everyone is entitled to enjoyment of rights and freedoms of the Constitution, which is a similar provision as previously stated in the Constitution of Kunta Kinte. Now, in that case, the Court found that everyone included sexual minorities, albeit the fact that they pertained to a different sexual orientation. Now, in concluding this particular point, everyone must be interpreted to include the sexual minority group. any other interpretation would not only deprive this group of fundamental human rights, but more so, it would be contrary to international human rights laws. More than this, failing to accept this blanket protection would lead to questions as such as what other rights under the Charter are these particular, or is this particular sexual minority group now not entitled to based on their sexual orientation? If it pleases the court, I would like to move to my second submission, which pertains to immorality.
Counsel, before you move to the second point, I've been listening carefully, and it would appear your submissions to this court would assume that we are a municipal court. I would have wanted to hear you relate the arguments you made to the Charter. I haven't heard you do much, other than for the rights of freedom of expression and freedom of association. If I may ask you a question, have you referred to Article 17.3 of the Charter? I understand when you refer to Article 2, but could you go to Article 17.2? Have you made reference to Article 17.2, which talks of the need to protect moral traditional values?
Thank you for that.
17.3, sorry. It is Article 17.3 of the Charter.
Thank you for that submission.
Sorry, Counsel, before you proceed, and please, you mustn't forget what you are going to say. You are asked not to be too fast as well.
Okay. Thank you, Honourable Justices. To answer the question by the Honourable Judge pertaining to Article 17.3, the applicant makes its submissions based on the fact that morality is not a static concept. Now, the first point of this is that morality in Africa has developed over time. The first demonstration, or the first problem that the applicant finds in basing the denial or the limitation of the rights of the members of Nugal is that the morality in this question is based on an old and outdated colonial law. More so, the revival of this outdated and old colonial law was reprived in a 2002 opinion poll, and in order to address this, the applicant would like to refer the court to the decision of Legal Resources Foundation versus Zambia, where the Commission expressly stated that justification for limitations cannot be derived solely on popular will.
Counsel, isn't part of the justification for proscribing the registration of Nugo, embedded in the deeper African customs and traditions which don't appear to recognize sexual minority rights?
Thank you for that submission, Honourable Justice. On that point, the applicant would then like to refer the court to the following decisions and the following decisions and resolutions of the African Commission. And the reason for this submission is to demonstrate that the African values and the African ideas of morality have in fact developed to the point where Africa as a state is ready to recognize that homosexuality and the protection of homosexual rights is at a right place to be recognized. The first submission is the decision of the Commission, or rather a statement made in obiter of the Commission in the Zimbabwe NGO Forum, where the Commission said that the aim of the principle of equality is to ensure the equal treatment for individuals irrespective of their sexual orientation. I then refer the court to Zimbabwe Lawyers and Human Rights and Associated Newspapers versus Zimbabwe, where in 2009 we see the Commission stating that Article 3 guarantees a fair trial and just treatment of individuals within the legal system of a given country. Now, the aim of the principle is to ensure equality of treatment of individuals, again, irrespective of sexual orientation. I then refer the court to Resolution 275, which is a resolution on the protection against violence and other human rights violations against persons on the basis of sexual orientation. Lastly, I refer the court to the fact that the Coalition of African Lesbians was granted observer status by the Commission in its 56th session.
Counsel, the African Charter is one of the few human rights instruments that contains rights and duties. I haven't heard you on Article 27.2, which requires rights to be exercised with due regard to the rights of others, including collective security, morality, and common interest. What do you say to that?
Thank you for that observation, Honourable Justice. Article 27.2 does in fact serve as a limitations clause to the rights exercised in the African Charter. However, in dealing with this particular matter, the grounds of limitation would most likely be on the basis of morality, and on that point, the applicant submits that the morality of Africa has developed to a stage, based on the examples that were given and presented to the court, that the morality of Africa does no longer recognize or is no longer the position where sexual minorities are no longer included in that protection. More so, on that point, the protection of the Charter, the protection of homosexuals in the Charter cannot be denied solely on the basis that the Charter does not in itself expressly mention homosexuals or sexuality as a protected ground. And this can be seen firstly in the extension of the fact that other statuses can be extended, as was the case in Peruit, and more so if the court is pleased to hear submissions based on the cases of Tunin and Young. This is a further demonstration that Article 2 can in fact protect homosexual groups under the banner of either sex or other statuses as found in Tunin and Young, respectively.
Thank you, Counsel.
Thank you, Honourable Justice.
Thank you. Yes, Counsel, you may proceed.
Monsieur le Président, honorables membres de la Cour africaine des droits de l'homme et des peuples, nous sommes Maître Chisungu et nous vous réitérons nos salutations les plus distinguées. À la suite de notre consort, nous plaidons aujourd'hui devant vous l'indolence de l'État du Kunta Kinte face à la pratique du trocosi, mais également des mutilations génitales féminines et du repassage des seins. La femme sera-t-elle à jamais contrainte à accepter les atteintes portées à son intégrité physique, à sa dignité humaine et à son épanouissement culturel au nom d'un quelconque respect de coutumes qui ne tiennent leur légitimité que dans l'ancestralité? L'article 5 du protocole à la Charte africaine des droits de l'homme et des peuples, relatif aux droits des femmes, enjoint les États à interdire et à condamner les pratiques traditionnelles néfastes qui affectent négativement les droits humains fondamentaux des femmes. C'est ainsi que dans son ouvrage « Chronique internationale collaborative », que l'auteur Dolin Lanta affirma ceci: « Toute coutume, peu importe sa nature, doit évoluer parallèlement à la reconnaissance des droits humains. Dans cette optique, elle peut être mise en péril lorsqu'elle constitue un bouclier elle constitue un bouclier des pratiques en violation avec ces mêmes droits supposés inhérents à la personne
Sorry, Counsel.
humaine.
Just remember not to be too fast.
Merci, honorable. La région Bamileke du Kunta Kinte est réputée pour être le sanctuaire du trocosi. Dans sa définition, le trocosi signifie tro, Dieu, et kosi, esclave, littéralement esclave des dieux. Au nom d'une telle pratique, elles sont 7000 femmes victimes de cette pratique Elles sont arrachées à leur famille et livrées à des prétendus féticheurs en guise de réparation, à des crimes qui auraient été commis par leurs ascendants, leurs aïeux, des crimes dont on ne se souvient même plus. Ils vous diront, la mémoire des hommes peut oublier, mais la mémoire des dieux, elle, n'oublie jamais. Parmi elles s'inscrira bientôt la petite Marina. La petite Marina n'a que 15 ans. En ce moment où nous tenons ce procès, sa vie est en train d'être dédiée, en région Bamileke, à ces prêtres à l'allure de saints, mais au cœur assoiffé d'innocence et avide de virginité de leurs victimes. En effet, à leur première menstruation, ces jeunes adolescentes deviennent des objets sexuels et charnels, qui vont jusqu'à porter la progéniture de leur propre bourreau. Il est inconcevable qu'en ce XXIe siècle, l'État du Kunta Kinte laisse perpétrer une telle pratique, en sachant pertinemment que ses obligations en la matière consistaient en l'adoption de lois pénalisant la pratique du trocosi, en la condamnation et la répression des esprits les plus réticents qui souhaiteraient s'y adonner. La Cour de justice.
Counsel, is it accurate to say the state closed its eyes completely? The state did take some action. It spoke to traditional leaders about these harmful practices, and research shows that after them engaging the traditional leaders, the practice actually decreased.
Merci pour votre question honorable.
Excusez-moi, et peut-être pour pouvoir compléter cette question, ici, enfin, le cas hypothétique mentionne 7000 femmes et jeunes filles qui sont victimes de cette pratique. Donc, sur une population de 70 millions d'habitants, est-ce que vous ne pensez pas que l'État a déjà fait suffisamment d'efforts et que ces efforts-là, de toute façon, continuent toujours à être menés pour que cette pratique prenne fin?
Merci également pour votre remarque honorable. Il est dit dans le rapport factuel que l'État du Kunta Kinte a mené des campagnes de sensibilisation. Soit. Mais que l'État du Kunta Kinte nous le dise ce matin. Quel est le poids d'une campagne de sensibilisation face à un droit en vigueur qui entérine, qui codifie le droit coutumier sans réserve et par conséquent légalise la pratique du trocosi? Honorable, permettez-nous...
Counsel, before you proceed, to what extent should an individual's consent to engage in this trocosi be accommodated in this whole debate?
Merci pour votre question. Relativement au consentement en jeu d'une personne dans ce débat, Honora ferait-il certainement référence à l'attachement du peuple Bamileke à cette pratique qui constitue l'une de leurs valeurs culturelles. Mais il ressort de l'article 17 du protocole de Maputo que les États ont le devoir, ont l'obligation de garantir aux femmes le droit à un environnement culturel positif et non de participer à les maintenir captives dans les prisons des traditions les plus nuisibles. Permettez-nous de nous référer à une jurisprudence. La Commission africaine.
É possível esclarecer como é que faz a diferença de cultura positiva e prática cultural negativa? Posso repetir a pergunta? Eu gostaria de saber como é que ela faz a distinção.
Sorry, colleague. There was no translation. Maybe my colleague can start. Oh, okay.
Sim, eu gostava de saber dela como é que ela faz a distinção entre prática cultural positiva e prática cultural negativa, atendendo que todas as práticas culturais estão imbuídas de tabus, E as pessoas fazem porque acreditam.
Merci pour votre question, honorable. Cette question qui nous permet de nous référer à l'article 1er, au point I du protocole de Maputo, qui définit une pratique néfaste comme un comportement, une attitude ou une pratique qui affecte négativement les droits fondamentaux, tels que le droit à la vie, à la santé, à l'éducation, à la dignité ou à l'intégrité physique. En ce sens, une pratique culturelle néfaste peut être considérée comme toute coutume qui porte atteinte aux droits fondamentaux des femmes, notamment le droit à la vie, à l'éducation, à la santé, comme ces pratiques telles que la mutilation génitale féminine et le repassage des seins, le droit à l'intégrité physique, le droit à la liberté tel que le troc-aussi. Honorable, permettez-nous de lever tout équivoque. Nous n'entendons point faire le procès de la culture africaine. Nullement. La preuve en est que je suis une femme africaine, fière de l'être, fière de mon identité, pure congolaise de la RDC. Seulement, nous reprochons ici, honorable, que l'État puisse tolérer toute pratique coutumière qui déshumanise ou encore qui porte atteinte à l'intégrité physique ou morale d'un être humain. C'est ce que nous reprochons à l'État du Kunta Kinte. Et en l'espèce, permettez-nous de nous référer, comme nous l'avions dit, à la jurisprudence Serra contre le Nigeria. La Commission africaine a affirmé...
Counsel, before you do that, I asked the question about the extent to which individual consent to have one's rights violated could be accommodated in this debate. Could you just clarify, if an individual submits to these practices, and happily so, what standard should we use to hold that there is a violation of their rights?
Merci pour votre question, honorable. Il est vrai que les peuples balbélékés peuvent se soumettre volontairement à la pratique du troc-aussi. Mais comme nous le disions tantôt, l'État est pour la population ce qu'est un père pour un enfant. Il peut être vrai qu'ils croient aveuglément en cette pratique, mais il est de la responsabilité de l'État, conformément à la communication de la Commission africaine Zimbabwe NGO Forum contre le Zimbabwe, d'être le premier responsable de la protection des droits de l'homme. Alors quand bien même il ne se rendrait pas compte, il ne réaliserait pas que cette pratique va fortement à l'encontre des droits humains, l'État ne doit pas rester laxiste, l'État ne doit pas rester indifférent, parce que ce sont des vies qui s'éteignent. Son obligation est d'y répondre fermement, soit par des mesures législatives ou des mesures répressives, ce que nous ne constatons pas bien évidemment dans les faits. Il ne suffit pas de procéder à des campagnes de sensibilisation,
Counsel,
mais il suffit...
Counsel, would you say that in those circumstances, such consent is true consent?
Pardon?
Would you say that in those circumstances, such consent as a woman or girl can give is true consent?
Merci pour votre question. Un consentement véritable, étant donné, honorable, qu'il s'agit de pratiques ancrées, de transmises de génération en génération, à un moment donné, la population ne cherche plus à savoir le bien fondé de cette pratique. Elle l'applique tout simplement aveuglément, au nom d'une certaine ancestralité. Nous pouvons donc dire qu'en l'espèce, ce tel consentement de la part des femmes ou encore des familles qui livrent ces jeunes filles n'est nullement éclairé à la lumière des droits de l'homme.
Well, your time is up. I'll give you 1 minute to wrap up.
Merci, honorable. Comme nous le disions, la Cour de justice de la Communauté des États d'Afrique de l'Ouest, en affaire Adijatou, contre le Niger, et la Cour européenne des droits de l'homme, en l'affaire Siliadine contre la France nous donne deux jurisprudences sans équivoque. Un État peut être tenu responsable de ces défaillances, à protéger efficacement le droit des victimes d'esclavage et de servitude. Et sur cette base honorable, nous engageons la responsabilité de l'État du Kunta Kinte pour avoir failli à protéger efficacement le droit des femmes bamileke à l'égard du trocosi, des mutilations génitales féminines ainsi que du repassage des seins. Nous avons plaidé.
Thank you, Counsel. I now invite the first oralist for the respondent. You will bear in mind all the requests I've been making to oralists not to be too fast as you give us your presentation.
Much obliged, Your Excellencies. Your Excellencies, as earlier introduced, I am Aboto Judith Marian, counsel for the respondent. I will be responding to the applicant's first submission with regard to the issue of jurisdiction and admissibility. Your Excellencies, as a guide to my submission, I will proceed under two heads of argument. Firstly, that the African Court has no jurisdiction over the matter, and that secondly, this case, the elements of this case are inadmissible and thus the case should be struck out. Your Excellencies, the applicants firstly submitted that this court has jurisdiction over this case. However, the respondents contend that submission and submit that this court has no jurisdiction over this case by virtue of the fact that in paragraph 23 of the facts, Kunta Kinte withdrew its ratification of the African Court Protocol, which provides this court with jurisdiction. The applicants have argued that the withdrawal from the African Court Protocol was invalid and unregulated. However, the respondents submit that this was valid and it was regulated by virtue of Article 56 of the Vienna Convention on the Law of Treaties. Your Excellencies, under Article 56, Clause 1 of the Vienna Convention on the Law of Treaties, it provides for countries or state parties to particular treaties to withdraw from those treaties even though there is no withdrawal clause, provided that it can be inferred from the nature of the treaty, and secondly, that there is a possibility of intention. Your Excellencies, by virtue of the fact that the African Court Protocol does not expressly state that a particular state party cannot withdraw from it, the withdrawal is actually in line with international law. And more so, Your Excellencies, this was observed by the African Commission itself.
Counsel, we have had arguments from the applicants on the effect of Article 56.2 of the Vienna Convention. I still want to take you back to the Constitutive Act of the African Union. You are a member state. Article 31 provides, for instance, in Article 2, that during the 1 year referred, that is, if there was an application for secession, the member state wishing to withdraw from the Union shall comply with the provisions. Here we are talking of a period of 1 or 2 months. The announcement to withdraw was in June. Was in May, the application was brought in June. And you're talking about international law. Can you relate the two? The position in international law which allows for notice, which was made, a point made by the applicants, and the 1 month between the announcement of the withdrawal and the lodging of the application.
Thank you, Your Excellency. We do understand your concern with regard to Article 56, Clause 2, and indeed the respondents concede that the period of 12 months' notice as provided for in Article 56, Clause 2 of the Vienna Convention on the Law of Treaties has not yet been complied, has not yet been fulfilled with, as we can see that the announcement or the notice of withdrawal was sent in May of 2016, and it is not yet 12 months. However, Your Excellencies, with regard to consent and the principle of sovereignty, D. Russo has expounded on the element of procedure obligations and good faith in his article on procedure obligations and good faith, the case of human rights treaties. And he has stated that, be that as it may, that the 12-month notice is not, it has not yet been complied with, that the element of consent is the overriding factor with regard to international courts. And more so, Your Excellencies, even if the state of Kunta Kinte has withdrawn its ratification of the African Court Protocol, we do not see any violations of the African Charter, as my co-agents will proceed to further on prove to this Honorable Court. Your
Counsel, eu gostaria de saber se o fato do Tribunal aceitar o argumento que está a submeter ao Tribunal de que podemos considerar o fato de este tempo que a lei permite ou que prescreve para que seja respeitado para que o consentimento do Estado em não estar vinculado ao protocolo seja respeitado, nós estaríamos a pôr em causa o princípio da segurança jurídica para os cidadãos do seu próprio Estado, porque eles têm uma expectativa em relação ao Tribunal Africano e à proteção. Obrigada.
Thank you very much, Your Excellency. In response to your question, Your Excellency, we do understand your concern with regard to accepting our argument and consent. However, we should look at the facts within Kunta Kinte and the situation as it is, as can be seen in paragraph 9 of the facts, that Kunta Kinte is actually still party to the African Charter, and it has actually incorporated various human rights instruments within its constitution. So accepting that this court is not bound, that the jurisdiction of this court, that the court does not have jurisdiction over this particular matter, it will not be putting the legal security of the inhabitants of Kunta Kinte at stake, because Kunta Kinte is actually still party to the African Charter and is bound by it.
So, are you now saying that the court has jurisdiction?
Much obliged, Your Excellency. In the event that this court deems that it has jurisdiction, the respondent's submission was that this court does not have personal jurisdiction. And in the case of Mikelo Tiago Gambaye versus the state of Senegal, it was stated that this court must have personal jurisdiction, temporal jurisdiction, territorial jurisdiction, and temporal jurisdiction over a matter before it handles it. But in the event, in line with Article 3, Clause 2 of the Protocol, if this court deems that it has jurisdiction, the respondents still submit that the elements of the case are inadmissible, as the applicants have actually not complied with Article 56, Clause 5 of the African Charter on exhaustion of local remedies, Your Excellencies. And more so, Your Excellencies, the applicants have argued that with regard to the detention of inmates of PDF, that they exhausted all local remedies. However, the respondents submit that in paragraph 16 of the facts, in paragraph 18 of the facts, Rights Without Borders did not pursue a further appeal to the Supreme Court, which is the highest court within the Republic of Kunta Kinte, as can be seen in paragraph 6 of the facts. With regard to the issue, Your Excellency, in respect to the registration of new
You have moved away from the jurisdiction question?
Yes, Your Excellency. In the event that you deem that you have jurisdiction, we still submit that the elements of the case are inadmissible. Okay, Your Excellency.
Counsel, that very paragraph 18 that you refer to said that the Supreme Court had subsequently to the earlier ruling, rejected several applications, and then the applicants felt that it was of no consequences to go back to the Supreme Court. What do you say to that?
Much obliged, Your Excellency. I actually do understand your concern with regard to that issue. However, in Article 19 versus Eritrea, and also the Human Rights Committee decision in A versus Australia, it stated that the applicant cannot cast aspirations about the effectiveness of local remedies. And even though it has doubts about the effectiveness of local remedies, it is not absolved from actually exhausting them. So as can be seen in the facts in paragraph 18, Rights Without Borders, which was the original author of this communication, did not exhaust the local remedies by applying to pursuing a further appeal to the Supreme Court. Your Excellencies, I beg to proceed to respond to the issue on exertion of local remedies with regard to the timely institution of matters on regard to the issue of Newgal, Your Excellency. In Article 19 versus Eritrea, it was stated by the African Commission itself that the complexity of an issue, the complexity of a matter should be taken in due regard with regard to undue prolongment. So much as the case has been pending from 2012 to 2016, the fact that the case of Newgal exposes complex issues should be taken in due regard. And we ask this Honourable Court to deem that this length of time is not undue prolongment, Your Excellencies.
One question, and I have no problem with the timely submission. I want to take you back to the admissibility.
Okay, yes.
Are you saying that the Jawara exceptions do not apply to the applicant's case? You're familiar with the Jawara exceptions where the effectiveness, the availability, you are saying they do not apply to the applicant's case?
Much obliged, Your Excellency. The respondents do not say that. The respondents are actually aware that Jawara versus the Gambia stated that for local remedies to be exhausted, they must be available, they must be sufficient, and they must be effective. The respondents submit that the local remedies within Kunta Kinte are actually available, as can be seen in paragraph 6 of the facts, that we actually have judicial bodies ready to handle these cases. However, the applicants have argued that these local remedies are not effective and they're not sufficient. But the respondent is submitting that actually these local remedies are effective. It is just that the applicants have run away from exhausting them. They have not exhausted them, and that is why the effectiveness is in question here.
Counsel, I want to pursue you on this question. We are told the Chief Justice called a press conference where he apparently manifested bias, and as a state party, you are ready to stand to that conduct, that there was effective remedy?
Much obliged, Your Excellency. In response to your question, the statements of the Chief Justice were actually written down in the facts in paragraph 22 of the facts. However, Your Excellencies, the statements made by the Chief Justice do not amount to exhaustion of local remedies because, one, the statements were made in a press release and that was not a court of law. And statements made by judicial officers outside the courts of law do not amount to precedent or do not amount to exhaustion of local remedies, Your Excellencies. Your Excellencies, I beg for 1 minute to conclude with my submission.
Okay, I'll give you 1 minute.
Thank you, Your Excellency. With regard to the response on the applicant submission on the Trokosi custom, in the facts, the applicants have not stated anywhere, in the facts do not state anywhere that the applicants have actually challenged the abolition of the Trokosi custom within the courts of law in Kunta Kinte. Your Excellencies, the applicants relied on the case of Diabla versus Sudan, but that case is significantly distinguishable from the facts beforehand because the applicant, the author, the Rights Without Borders, had the opportunity and had access to court, Your Excellency.
Didn't the government had an obligation to take legislative measures to bring this practice to an end? And if it did have such an obligation, did it take such measures?
Much obliged, Your Excellency. Yes, the government had an obligation to take legislative measures. The government, firstly, in its 1984 constitution, incorporated the International Covenant on Civil and Political Rights, which is against, which prohibits slavery, and servitude. And more so, Your Excellencies, we should take note of the fact that, yes, much as legislation can be taken as a measure.
Sorry, Council. The Maputo Protocol requires the state to take legislative and other measures, but those measures have to be backed by sanctions. And what do you say to that?
Much obliged, Your Excellency. The respondents beg Your Excellencies to understand and take note of the situation in Kunta Kinte, that the Kosi custom has been actually embedded in the culture of the people in Kunta Kinte. However, Your Excellencies, be that as it may, that there are legislative measures backed by sanctions, we should take a look at the precedent or the situation in the country of Uganda, where there is actually the Female Genital Mutilation Act, which prohibits and actually sanctions the act of female genital mutilation. But because the custom is embedded in the culture of the people, it has taken a long time for it to actually yield fruit.
So is that an admission that the government failed to either ensure that there were sanctions for violating these instruments, or if it did, but then it failed to enforce those sanctions?
Much obliged, Your Excellency. This is not an admission that the government failed. The respondent's submission is that the government has tried its best. It has spoken to the culture leaders in Kunta Kinte. It has taken those measures provided for in Article 5 of the Maputo Protocol, which provide that the government can take legislative and other measures. And the other measures that we have talked to the cultural leaders. If failure to provide sanctions amounts to a violation, Your Excellency, we beg to take note of the practicability of a legislation. If I may be of no further use to this Honourable Court, I beg to yield the floor, Your Excellencies, to my co-agent, Pedro Tembe, who will handle the response with regard to the detention of inmates of PDF. Thank you.
Thank you, Council.
Venerando juízes do Tribunal Africano dos Direitos do Homem e dos Povos, ilustres representantes da Comissão Africana dos Direitos do Homem e dos Povos, a todos presentes. Irei proceder à abordagem das questões de mérito.
There's no translation.
Council, please start afresh. There was no translation, at least English translation, I didn't hear.
Venerando juízes do Tribunal Africano dos Direitos do Homem e dos Povos, ilustres representantes da Comissão Africana dos Direitos do Homem e dos Povos e a todos presentes. Irei começar por abordar as questões de mérito, focando na alegada violação à Carta Africana em relação às circunstâncias de detenção e condições de detenção dos presos na prisão do Paraíso, abreviadamente designada PDF. Contudo, cumpre-me referir uma questão prévia, que prende-se com o artigo 23 do Protocolo do Tribunal Africano, que estabelece que o Tribunal poderá apreciar casos, caso tenha...
Sorry, Council. You are requested not to be so fast. The translators can't keep up with your pace.
Como questão prévia, cumpre-me referir o previsto no artigo 23 do Protocolo do Tribunal Africano, que estabelece que o Tribunal apreciará casos caso tenha um quórum de pelo menos 7 juízes. No caso em apreço, não estamos perante este fato, uma vez que a composição do Tribunal é de 6 juízes.
Council, has that point been taken in your memorial?
Contudo, não sendo esse o entendimento do tribunal, prosseguem os termos da presente contestação. No que é alegada violação à Carta Africana em relação às circunstâncias de detenção e condições de detenção, o Estado de Kunta Kinte é membro da União Africana e constitui um dos princípios desta organização nos termos da linha O do artigo 4 do seu ato constitutivo, a condenação e rejeição de atos terroristas e atividades subversivas. Foram praticados atos terroristas em Malinque, na medida em que um grupo de centenas de jovens, denominados Panteras Jovens, invadiram as instalações do governo local, tendo-os incendiado e decapitado 5 altos funcionários. Ao proceder desta forma, os referidos jovens foram contra o previsto no artigo 27, número 2 da Carta Africana, que estabelece que os direitos e liberdades fundamentais exercem-se no respeito dos direitos de outrem, da segurança coletiva, da moral, bem como do interesse comum. A conduta dos referidos jovens enquadra-se nos elementos constitutivos da tortura, tal como dispõe o artigo 1º da Convenção da União Africana, na sua linha A, número 3, posto que esse dispositivo estabelece e define como ato terrorista todo aquele que cause a morte de um grupo de pessoas. No caso em concreto, foram decapitados 5 altos funcionários. Destrua a propriedade pública. No caso em concreto, foram incendiadas as instalações do governo local, com o fim de exercer pressão sobre um governo para que esse abstenha-se de uma iniciativa ou proceda a uma iniciativa. No caso em concreto...
Maître, j'ai une question. Les faits qui sont allégués, en tout cas dans le cas hypothétique, n'ont pas été commis sur le territoire de Kunta Kinte. C'est beaucoup plus, d'après ma compréhension des faits, ces faits ont été perpétrés dans la République de Malinké. Alors, quelle est la base juridique sur laquelle la République de Kunta Kinte assoit son argumentaire pour arrêter les jeunes de Young Panthers?
Thank you very much. No âmbito da obrigação de prevenir contra o terrorismo, que resulta dos princípios e diretrizes sobre direitos humanos no combate ao terrorismo em África, estabelece como obrigação dos Estados, de, entre outras, o lançamento de alertas, ou seja, o aviso aos outros Estados sobre atos terroristas ou autores de atos terroristas. E assim, porque o Estado está adstrito a obrigações especiais no âmbito de direitos humanos e porque a paz e segurança dos povos é direito deles, o Estado viu-se na contingência de deter os jovens ao abrigo da Diretiva de Segurança Humana prevista nos princípios e diretrizes sobre direitos humanos no combate ao terrorismo em África. Prosseguindo. Ademais, o direito à liberdade advogado em muitos instrumentos internacionais de direitos humanos não é absoluto, no sentido de que pode conhecer limitações e, neste caso, veja-se os parágrafos 68 e 69 do caso Meet the Rights Agenda versus Nigeria, em que a Comissão Africana, sabiamente, considerou que a limitação do direito à liberdade só pode ser com fundamento na violação do artigo 27, número 2 da Carta Africana, e é o que se verifica no presente caso, na medida em que os Panteras Jovens foram contra este preceito legal. Aliás, sobre essa questão, veja-se o parágrafo 73 do caso Instituto Africano para os Direitos Humanos e Desenvolvimento contra a Guiné, onde a Comissão Africana estabeleceu que o governo da Guiné tinha direito de proceder contra todas as pessoas que acreditassem que representassem uma ameaça à sua segurança estatal. E no caso em concreto, o terrorismo é sem dúvida uma ameaça à segurança de qualquer Estado. No tocante à alegada demora com a prorrogação das prisões preventivas, ora, não existe uma definição líquida, uma definição exata do que seja prazo razoável. E, nesse sentido, a Comissão Africana estabeleceu, no caso, artigo 19, contra a Eritreia, que para a aferição do que seja um prazo razoável, se deve ter em conta como um critério também a complexidade do processo, sendo certo que a complexidade do processo implica que se deve ter em conta o número de pessoas envolvidas e, no caso em apreço, não se está perante um nem dois, muito menos 3 cidadãos. Está-se perante aproximadamente 700 cidadãos e, no caso em concreto, justifica-se que haja necessidade de investigar sob pena de se cometerem injustiças. Aliás, o Estado de Kunta Kinte já tem desenvolvido atitudes no sentido de julgar os jovens e que resultaram na condenação de 150 deles.
Maître, j'avais une question, parce que, en tout cas, le paragraphe 16 du cas hypothétique pose quand même une certaine difficulté juridique, parce que là, nous avons des personnes qui peuvent être détenues pendant 3 mois, renouvelables de manière indéfinie. C'est bien ce que le cas hypothétique précise. Est-ce que vous ne pensez pas que dans n'importe quelle procédure criminelle ou pénale, il faudrait qu'on puisse avoir quand même une durée précise de détention des personnes qui sont soupçonnées d'avoir commis des infractions, et pour ne pas que cette détention-là soit finalement un peu trop longue, sinon exagérée.
Thank you very much. A questão do prazo razoável é controvérsia. No sistema europeu, estabelece um lapso temporal, que é de 6 meses, ou seja, após 6 meses, caso não se tenha providenciado a justiça ao arguido, considera-se que o prazo razoável foi violado. Mas no sistema africano não há esse lapso temporal, tendo estabelecido por via disso a Comissão Africana, por via do caso artigo 19 versus Eritreia, alguns critérios para a aferição desse prazo, no sentido de que deve ter em conta a complexidade do processo. E no caso em apreço, o terrorismo é uma situação complexa que coloca e merece muita atenção por parte dos povos.
Council, if I take you to Article 7 of the African Charter, which basically talks about fair trial principles, which requires the right of an individual's right to be heard within reasonable time. Are you arguing that reasonable time in the case of Kunta Kinte was indefinite? That the Attorney General, the prosecutor, could use the criminal procedure provisions to indefinitely renew the detentions? Is that what you are telling us?
Thank you very much. A prorrogação dos prazos de prisão preventiva são previstos nos termos do Código de Processo Penal do Estado de Kunta Kinte. Havendo necessidade de proceder a mais investigações sob pena de se cometerem injustiças.
I'm not sure, Counsel, if I understood that answer. Would you mind repeating that answer?
A prorrogação dos prazos, a prorrogação da prisão preventiva no estado de Kunta Kinte é estabelecida por lei e, por conseguinte, não pode ser considerada arbitrária. No sentido de que, havendo necessidade de proceder a mais investigações tendentes à descoberta da verdade material, o Estado pode prorrogar a prisão preventiva, sob pena de se cometerem injustiças.
But isn't the question that my colleague asked, directed at saying, is it your submission that provided there are renewals or extensions, it doesn't matter how long it can take, there is no infringement of fair trial rights? Is that your submission?
Thank you. Claramente que não, na medida em que é fundamento do Estado a prossecução da justiça às pessoas. E, nesse sentido, enquanto menos tempo possível o Estado prover a justiça às pessoas, melhor. Contudo, nem todos os casos são iguais, havendo uns com particularidades que outros não têm. E o caso do terrorismo é uma dessas situações.
Thank you, Counsel.
Queria fazer mais uma pergunta assim. Será que a gravidade do caso quer dizer, os direitos humanos devem estar dependentes da gravidade do caso? É o que está a nos tentar dizer? Sim. O que eu quero saber é se o fato, porque deu a entender que trata-se de um crime de terrorismo e pela gravidade deste crime, os direitos humanos devem ser de alguma maneira sobrepostos por causa da gravidade do crime que foi praticado.
Muito obrigado pela pergunta. O terrorismo coloca em causa a estabilidade, bem como o desenvolvimento de qualquer país. E no caso em concreto, se o Estado não tivesse tomado medidas no sentido de deter os jovens, ou seja, limitando o seu direito à liberdade previsto na Carta Africana, o Estado estaria a ir contra um outro princípio, que é de que os povos têm direito à paz e segurança nacional. E nesse sentido, houve necessidade de limitar o direito na medida em que o fundamento é a violação por parte dos jovens panteras do artigo 27, número 2 da Carta Africana.
Your time is up, Counsel. You can wrap up if you want to, but if you are done. Thank you very much.
Eu gostava de concluir. No que a alegada violação dos direitos humanos, no tocante à detenção dos jovens, ou seja, na prisão de PDF, o autor alega que o Estado violou o direito à saúde, bem como direitos similares. Ora, não há elementos materiais que sustentem os fatos alegados pelo autor. E, neste sentido, veja-se o parágrafo 56 do caso Dado a Jawara versus Gambia, em que o autor, Dado a Jawara, considerou que o Estado violou, ou seja, violou os direitos dos detidos ao mantê-los incomunicáveis. E, nesse sentido, o Estado confrontou a apresentar elementos materiais sobre este fato. Contudo, o autor nada apresentou, tendo a comissão decidido que não poderia vislumbrar nenhuma violação dos direitos dos detidos, uma vez que o autor não havia apresentado evidências sustentáveis desses fatos. Muito obrigado.
Thank you, Counsel.
Senhor Presidente, venerandos juízes do Tribunal Africano dos Direitos Humanos, digníssimos representantes da Comissão Africana, meus senhores e minhas senhoras. Meu nome é...
I'm sorry. Okay. There was no translation, but at least for English, I think he's back. Thank you. You may proceed, Counsel.
Senhor Presidente do Tribunal Africano dos Direitos Humanos, venerandos juízes do Tribunal Africano dos Direitos Humanos, digníssimos representantes da Comissão Africana, meus senhores e minhas senhoras. Meu nome é Leopoldina Gouveia. Antes de mais, com a permissão do Presidente, gostava de levantar outra questão prévia. Salvo melhor compreensão, no início da sessão disse que o venerando juiz-presidente e a veneranda juíza Penseplácula são naturais da África do Sul. E, nos termos do número 2 do artigo 11 do protocolo à Carta Africana relativa ao Tribunal Africano, não poderão ser aceitos 2 juízes nacionais do mesmo Estado.
Counsel, as I asked the other counsel, was this point taken in your memorial?
Sim. Prosseguindo com as questões de mérito, cabe agora discutirmos a questão da alegada violação à Carta Africana pela recusa do registro da Associação de Lésbicas e Gays de Kutaquinte, que adiante designaremos de Nugal. Ora, a República de Kutaquinte é parte da Carta Africana dos Direitos Humanos e dos Povos, que adiante designaremos de Carta Africana ou simplesmente de Carta. E é signatário do Pacto Internacional dos Direitos Civis e Políticos e outros instrumentos internacionais de direitos humanos. E, quando os ratificou, fê-los ciente das responsabilidades e obrigações a que estaria adstrito. O artigo 2 da Carta Africana reconhece a todas as pessoas o direito ao gozo dos direitos e liberdades previstas na Carta Africana sem qualquer distinção. E o artigo 10 reconhece a todas as pessoas o direito de livremente constituir associações, sob reserva de se conformarem às regras prescritas na lei. No caso Moot versus Sudão, a Comissão entendeu que o direito de livremente constituir associação compreende o direito...
Counsel, you are asked not to be too fast as well. The translators are struggling to keep pace with you.
Obrigada pela observação. Prosseguindo, dizia que no caso Moot versus Sudão, a Comissão Africana entendeu que o direito à associação compreende o direito de livremente constituir ou participar em associação e que qualquer interferência com este direito deve ser prescrita por lei e observadas as condições previstas no número 2 do artigo 27 da Carta Africana, designadamente proteção dos direitos e liberdades de outrem, segurança coletiva, da moral e dos interesses coletivos. É evidente que o número 2 do artigo 17 da Lei das Associações de Kutaquinte não faz senão reafirmar o reconhecimento do direito à associação previsto no artigo 10º da Carta Africana. E porque este direito não é absoluto, pode-se restringir-se se os fins a que a associação se propõe forem ilegais ou prejudiciais ou ainda incompatíveis com, dentre outros motivos, a moralidade. A promoção e a proteção da moral...
Counsel, just a follow-up to what you have said. You have said that the rights in the Charter have to be exercised with due regard to the duties provided for in Article 27.2 of the Charter. But the Charter also has Article 28. And 28 says that individuals shall have the duty to respect and consider his fellow human beings without discrimination and maintain relations aimed at promoting, safeguarding, and reinforcing mutual respect and tolerance What do you then say to that?
Obrigada pela questão. Ora, segundo o relatório do estudo sobre a opinião pública realizado pela Broadcasting Company, demonstrou-se que 93% dos 70 milhões de habitantes de Kuta Kinte são pró-manutenção de uma norma constante da Lei das Infrações Penais que qualifica e criminaliza determinadas condutas como contrárias à natureza e, dentre elas, o homossexualismo. Ora, Kuta Kinte é um Estado democrático, baseado na liberdade e igualdade. 93% de 70 milhões de habitantes representam a vontade geral. Sim, representam a vontade geral, representam a vontade coletiva da população de Kuta Kinte. E há aqui proporcionalidade. Se não vejamos, os critérios para a aplicação do princípio da proporcionalidade são base legal, visar um interesse legítimo e tratar-se de uma sociedade democrática. Kuta Kinte é um Estado democrático. A restrição tem base legal, aliás, como estabelece o artigo 10 da Carta Africana. E visa, sim, um fim legítimo, que é a moralidade da população de Kuta Kinte.
Se posso fazer uma questão, está a dizer para nós que o fato de existir esse relatório que traz mais ou menos qual é a tendência da vontade da maioria do Estado de Kuta Kinte justifica essa limitação, mas não diz claramente na sua explicação por que é que está a considerar, por exemplo, que a homossexualidade é imoral, atendendo que o tribunal já lhe pôs uma questão ou já lhe fez referência ao artigo 28. Não acha que fazendo isso estaria a criar uma situação em que a maioria, não é? Neste caso, estaria a pôr em causa os direitos humanos das minorias? E se o Estado não intervir, quem é que vai proteger essas minorias?
Obrigada pela observação. Ora, vou chamar à colação a decisão da Comissão Africana sobre a atribuição do Estatuto do Observatório dos Direitos Humanos à coligação de lésbicas africanas, em que a própria Comissão Africana entendeu que os objetivos ou as finalidades que a coligação se propunha não diziam respeito à promoção nem à proteção dos direitos humanos estabelecidos na Carta. Ora, de fato, ao limitar-se o direito de livre associação, de fato estamos sim em face de uma restrição, mas devo destacar que a restrição dos direitos também é prevista pela Carta Africana. E a Carta Africana impõe ao cumprimento ou preenchimento de determinadas condições estas que foram preenchidas.
I want to get the facts right so that this court would determine your refusal to register, whether it was justified under the Charter. When you look at the facts in paragraph 21, it says the Constitution did not recognize homosexuals, and therefore the objectives of the organization were contrary to Section 17 of the Societies Act. But when you look at the objectives of the NOGAL, it was to seek right to health, those rights which really are fundamental and basic. I don't see where the unlawful purposes as required in the legislation, in as long as the objectives of NUGOL were to either get information about rights, non-discrimination, and right to health. Those were very noble objectives. Why do you think these contravened the Constitution and the Societies Act provision?
Obrigada pela observação. Tenho informação de que o meu tempo terminou e gostava de pedir apenas 1 minuto para responder a questão e concluir a minha apresentação.
You may have a minute, Counsel.
Sim. A Constituição de Kunta Kinte reafirma os direitos previstos na Carta Africana e consagra o direito ou os princípios da universalidade e igualdade. Não há disposição nenhuma da Constituição de Kunta Kinte em que se afirma que o Estado de Kunta Kinte não reconhece a existência de pessoas homossexuais. Os direitos à saúde, educação, que são direitos fundamentais, sim, para as pessoas, não são negados aos homossexuais, até porque são pessoas como quaisquer outras.
In other words, you are saying there was no basis for the rejection of the registration.
Obrigada pela questão. Ora, para responder à questão, vou chamar a colação o caso artigo. Aliás, para responder à questão, vou chamar a colação o caso Prince versus África do Sul, em que a Comissão Africana entendeu que o propósito de registro de uma associação era ou o propósito da recusa do registro da associação era geral e que, porque o direito à associação é um direito não absoluto, permitia sim a restrição. Tem informação que o tempo acabou.
Are those your submissions, Counsel, or you want to wrap up?
Sim, para concluir, gostava de chamar a atenção do Tribunal à resolução da Comissão Africana sobre o direito à liberdade de associação, que reconheceu que os Estados a regulamentarem o direito à associação deverão ter em conta as obrigações dos Estados decorrentes da Carta Africana. E a este respeito, gostava de chamar o número 3 do artigo 17 da Carta Africana, que impõe aos Estados a promoção e a proteção de, entre outros, a moralidade. E para dar continuidade à alegação, para dar continuidade a questões de méritos, gostava de, com a permissão do Tribunal, chamar o meu colega Simon.
Thank you, Counsel.
Mr. President, Your Excellencies, for the record, my name is Simon Ssenyonga, last counsel appearing for the respondents in this matter between the African Commission and the State of Kunta Kinte. Your Excellencies, I'll proceed on submitting on the fourth issue that the State of Kunta Kinte has not been complacent in regards to the issue of the abolition of the Chokosi custom, and subsequently does not violate its obligations under the African Charter and other international instruments that the State of Kunta Kinte has ratified. Your Excellencies, we concede to the fact that the Chokosi custom violates women's rights, violates children's rights, all embedded in the different treaties that the State of Kunta Kinte has ratified. However, Your Excellencies, the state of Kuntankite is alive to its obligations under Article 5 of the Women's Protocol, which I'll later on refer to as the Maputo Protocol. Your Excellencies, the African Commission, in the case of the Association of Violation of Post-Electoral Violence Victims and another versus the State of Cameroon, stated that a state has an obligation of result in the sense that they must show diligence in achieving the desired outcome of a particular law. Your Excellency, in this context, the Maputo Protocol, the standard of measurement of our diligence towards arriving to the obligations that we have under this treaty, Your Excellencies, have been elaborated in the case of the Cuba versus Belgium, a decision of the European Court on Human Rights, Your Excellencies, which noted that the compliance standard should be assessed in terms of the result achieved by both practical and legislative measures taken by a particular state. Your Excellencies, pursuant to Article 5 of the Maputo Protocol, but also directing you to paragraph 6 of the facts, Your Excellencies, a report by the Kuntankite Human Rights Observatory has clearly stated that for the past decade, the number of trocoses has reduced solely because of the engagement of the state of Kuntankite with the Bamileke people so as to stop the trocosi custom, Your Excellencies. In regards to the extent of having legal sanctions against this, Your Excellencies, I understand that this commission can share the same views with what the Special Rapporteur on the rights of African women noted. Ms. Soyata Maiga, in her report of 2015, in regards to the same custom happening in Ghana, Your Excellencies, clearly noted that the existence of legislative measures alone cannot put an immediate end to customs that have been deeply embedded amongst masses of individuals. Your Excellencies, the trocosi custom...
Council, just assist me. Has the state taken any legislative measures? Has it?
Much obliged, Your Excellencies. Pursuant to Chapter 2 of the Kuntankite Constitution, Your Excellency, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, and also the Maputo Protocol have been ratified by the state of Kuntankite. Therefore, they have been made justiciable in the Constitution of Kuntankite. This was the very point I was making, the view shared by Soyata Maiga, that even legislative measures in their existence, Your Excellencies, cannot put an immediate end. And therefore, Your Excellencies, the question now becomes a question of enforcement of these legislative measures. And Your Excellencies, to prove to this Honorable Court, I'll refer to two instances. And I refer to these instances to prove to this court that the circumstances in Kuntankite are not peculiar to Kuntankite alone, but other African states that are still grappling with the issue of deeply embedded customs that are still against legislative measures that have been taken, in fact, by other states against these particular customs. Your Excellencies, in the state of Malawi, there is an existence of the physical custom of sexual cleansing amongst the ladies. And in the state of Uganda, there is female genital mutilation. The two states, Your Excellencies, have adopted the Gender Equality Act in Malawi and in their penal code in Malawi still. In the state of Uganda, they have adopted the Prevention of Female Genital Mutilation Act, Your Excellencies. But, Your Excellencies, even in the existence of these very legislations, they have not put an immediate end. And these particular states are still taking progressive steps towards addressing these particular discrepancies arising from these rather inhuman customs, Your Excellencies.
Maître, j'entends votre argumentaire, mais il ne me convainc pas suffisamment pour une raison qui est toute simple. Vous ne pouvez pas utiliser des exemples dans d'autres pays dans lesquels peut-être la législation a été adoptée et on attend peut-être qu'il y ait peut-être une meilleure application pour pouvoir justifier le fait qu'il y ait des violations dans l'État que vous défendez. Je ne vois pas exactement comment vous pouvez adopter cette théorie un peu d'équivalence en fait. C'est pas parce qu'il y a des violations ou bien que des pratiques dans d'autres pays n'ont pas encore pris fin que vous pouvez dire ou prétendre que les pratiques à Kunta Kinte sont totalement acceptables ou bien compréhensibles. D'autant plus que vous avez vous-même indiqué au début de votre argumentaire que vous concédez le fait qu'il y a effectivement que ces actes-là, le truc aussi, constituent une violation de la charte africaine. Donc j'aimerais que vous puissiez peut-être donner d'autres arguments qui peuvent justifier le fait que l'État, depuis plus de 10 ans au minimum, sinon plus, n'ait pas pris suffisamment de mesures pour mettre fin à cette pratique.
Much obliged, Your Excellency. And Justice Amando, I do understand your concern. The submission I make in relation to the two states I refer to does not in any way seek to justify the Trokosi custom. It only seeks to draw the court's attention to take judicial notice of the fact that the circumstances in Kunta Kinte are not peculiar to Kunta Kinte alone. It shows that whereas other states, just like Kunta Kinte, have taken legislative measures, they still grapple with the question of enforcement of these particular sanctions arising from the measures.
You have not answered the question. You are probably repeating the same mistake. The issue here is, are you asking the court to take judicial notice of a harmful practice just because it happens in another country?
No, Your Excellency, that's not the averment of the respondent, Your Excellency. What we are clearly saying is that the state of Kunta Kinte, one, as a state committed to constitutionality and the rule of law, has taken particular appropriate measures pursuant to Article 5 of the Maputo Protocol. And therefore, whereas these appropriate measures are still yielding results, Your Excellencies, we still need to recognize the fact that the existence of legislative measures alone cannot put an end to customs that are deeply embedded amongst the peoples, Your Excellencies.
Yes.
We also understand that...
I just gostaria de trazer a sua atenção em relação a se considera ou não a lei instrumento educativo. Obrigada.
Justice Farida, that could be one way of looking at the obligation of the law. However, Your Excellency, we submit this honorable court that beyond just the law being an educative measure, the state of Kunta Kinte has taken other measures pursuant to paragraph 6 of the facts, Your Excellency, of engaging the Bamileke leaders to stop this Trokosi custom. The essence of this being to change the perception that obligations under human rights are not foreign notions. They are not preserved for the Europeans or the Americans, but are also existent for the African peoples and must therefore be observed, Your Excellencies. Just to settle our fears that may arise from this, Your Excellencies, we ground the submissions of the respondents on 4 particular measures that the state I'm proud to represent is willing to take, but also, Your Excellencies, will yield very significant fruits, Your Excellencies. In the 1 minute I'm left with, Your Excellencies, I'll direct this court to the fact that, 1, we're going to take specific legislation to address other harmful practices, as the African Commission has noted, towards female genital mutilation, breast ironing, but also clear abolition of the Trokosi custom, prosecuting any individuals who are caught practicing this custom. Your Excellencies, we seek to enforce.
Maître, excusez-moi, donc vous reconnaissez ici en fait qu'il y a une violation, vous allez maintenant prendre les mesures pour pouvoir y mettre fin. Mais en tout cas aujourd'hui, quand vous vous retrouvez devant cette juridiction, vous reconnaissez effectivement que cette Cour doit déclarer que votre État a violé la charte africaine en ne prenant aucune mesure contre cette pratique, le Trokosi. C'est juste pour avoir une clarification. Vous reconnaissez la violation, il n'y a absolument aucun doute. Maintenant, vous voulez prendre des mesures pour pouvoir y mettre fin. C'est bien ça?
Your Excellency, we acknowledge that the Trokosi custom violates the African Charter and other instruments. However, Your Excellencies, the plea of the respondents is that this honorable court should not find that the state of Kuntankite has not taken any measures, as the African Commission says, that we have been complacent in regards to fulfilling our obligations under the African Charter and other instruments, Your Excellencies. There is a clear distinction between the two. And Your Excellencies, Mr. President, if I may ask for only 1 minute.
Okay, before I give you 1 minute, clearly some measure was taken, maybe measures, but isn't the complaint of the applicants in effect that no adequate measures were taken and no justification has been advanced why adequate measures were not taken? We have talked about legislative measures. We know there was some discussion with local traditional leaders.
Much obliged, Your Excellency, and I understand the view arising from that. However, Your Excellency, it is the submission of the respondents in regards to that particular question that the question of adequacy should be measured against how effective it has proven to protect the rights of the women in Kuntankite. And Your Excellency, my submission being, the respondent submission being this, that the measures, the education measures taken have yielded fruits. However, Your Excellencies, it's still the respondents' averment that we're still committed to the cause of justice, and we're still taking much more excellent measures, so to say, that can particularly address for a long time and to avoid any future violations that may arise, Your Excellencies.
Okay, I give you now 1 minute then to wrap up.
Thank you very much, Your Excellencies. And the submission entirely of the respondents, Your Excellencies, the case of the respondents, they make before this honorable court that the arc of democracy, which the state of Kuntankite prides in very much, should bend towards the realization of justice. The case that the respondents make today, Your Excellencies, is not a case of only the respondents, but it is a case that we hope that you, the honorable members of the African Court, can come to our state and realize that we have taken measures, that the African Commission, which we work with closely, can also realize that we are doing whatever it takes to realize our obligations under the different instruments. But Your Excellencies, that we also pray that this court may find, declare and adjudge that it does not have personal jurisdiction over the case in relation to issue 1, and in relation to issue 2, Your Excellencies, that we did not violate the African Charter and other relevant instruments in the circumstances leading to the detention of the inmates of the PDF and the conditions under which they were detained. Your Excellencies, that the state of Kuntankite did not violate the African Charter and other relevant treaties by refusing to register Nugal. And finally, Your Excellencies, that whereas the Tukosi custom violates the African Charter, the state of Kuntankite is taking positive, progressive, and appropriate measures to ban this particular custom. Your Excellencies, if I may be of no further indulgence to this honorable court, I pray that the respondents rest their case.
Thank you very much, Counsel.
Much obliged, Your Excellencies.
Thank you. I shall now invite the oralist for the applicant who will present a reply. You will just, Counsel, remind us again your name.
Merci, honorable. Nous rappelons notre nom. Nous sommes Maître Chisongo.
Thank you, Counsel.
Merci, honorable. Juste assis ici, nous avons entendu beaucoup d'arguments de la partie défenderesse. Est-ce là l'intention de vouloir également fuir devant ses responsabilités? La question est posée. Mais au terme de l'article 11 du protocole de Ouagadougou, il ressort que vous êtes élu en fonction en raison de votre haute moralité, de votre compétence et de votre expérience juridique. En la matière, nous ne doutons point de votre compétence à rendre un jugement juste en droit. Nous aimerions revenir sur la question de la dénonciation. La partie défenderesse persiste et insiste sur la validité de cette dénonciation. Mais honorable, permettez-nous de rappeler qu'encore si cette dénonciation ne serait pas extraordinaire admissible, la Convention européenne des droits de l'homme ainsi que la Cour interaméricaine des droits de l'homme ont reconnu que la dénonciation n'a point d'effet rétroactif. Ainsi, elle ne peut délier l'État de ses obligations passées et il demeure responsable pour tous les faits qui ont constitué des violations antérieures à sa dénonciation. Elle a réaffirmé cela dans l'affaire grecque. La Commission européenne a estimé que l'État de Grèce ne pouvait alléguer de la dénonciation afin de fuir ses responsabilités relativement à ces violations des articles de la Convention européenne. Quant à la détention est arbitraire en raison de la durée illimitée, nous l'avons dit. Le Haut Commissariat aux réfugiés, dans son commentaire numéro 35, a déclaré que 48 heures est ordinairement suffisant pour conduire l'individu et le préparer pour une écoute judiciaire. La Commission africaine rappelle également dans l'Institut des droits humains et du développement en Afrique contre Angola que l'interdiction de l'arrestation arbitraire emporte l'interdiction des arrêts et détentions illimités dans le temps. Qu'en est-il de la question de la liberté d'association? La partie défenderesse a allégué que 93% de la population était d'accord avec le fait de maintenir l'article relatif à la prohibition de l'homosexualité. Honorable, permettez-nous de rappeler à la Cour la décision de la Cour européenne des droits de l'homme dans l'affaire Alex Keyes contre la Russie. Elle déclara que l'exercice des droits par une minorité ne saurait être conditionné par le consentement de la majorité. Ils allèguent également du droit des États à apporter des restrictions à des libertés. La Commission africaine, dont Yoris Le projette contre le Nigeria, affirme que les restrictions doivent être conformes aux obligations des États découlant de la Charte africaine. Or, les restrictions du Kunta Kinte sont contraires aux articles 2 et 3 de la Charte africaine qui leur imposent de ne point pratiquer de la discrimination et de respecter le principe d'égalité de tous devant la loi. Relativement à l'article 246, à la section 246 relative aux actes contre nature, honorable, cette loi est trop vague. Elle est tellement vague que l'État du Kunta Kinte se permet délibérément d'inclure dans sa définition les actes qui lui semblent, selon sa morale, selon son opinion personnelle, contraires à la morale. Aujourd'hui, l'homosexualité est considérée comme un acte contre nature. Demain, à quoi devons-nous nous attendre? Saluer une femme avec une bille sur la joue, demain, constituera-t-il un crime dans cet État? Dans l'arrêt Garde Dieu du Conseil d'État français, le Conseil a affirmé qu'une loi contraire, que la responsabilité de l'État peut être engagée pour une loi contraire à ses engagements internationaux qui porte un préjudice. Par conséquent, retenons alors que cette loi doit être abrogée. Et enfin, concernant le Trocosi, nous sommes heureux d'avoir entendu la partie défenderesse faire son mea culpa sur cette pratique traditionnelle. Ils allèguent également de leur prétendue ratification des protocoles du Maputo et du pacte international relatif aux droits civils et politiques. Il convient de leur rappeler qu'il ne s'agit pas de ratifier des instruments et de se coucher sur des lauriers et d'observer ces femmes subir la rigueur de ces pratiques. L'article 17 le leur impose. Ils doivent s'assurer que ces femmes vivent dans un environnement culturel positif. Et nous finissons avec cette jurisprudence de la Commission africaine, Serra contre le Nigeria. Le seul exemple où l'on peut dire qu'un État parti est en faute.
Sorry. I give you 1 minute to conclude.
Thank you, sir. En conclusion, Nous finissons avec la jurisprudence Serra contre le Nigeria. La Commission africaine a affirmé que le seul exemple où l'on peut dire qu'un État parti est en faute, c'est lorsqu'il n'a pas promulgué les lois nécessaires. En la matière, il s'agissait de promulguer une loi abrogeant la pratique du troc-aussi. Et l'État du Kunta Kinte ne l'a point fait. Par ces motifs, plaise à la Cour de reconnaître l'État du Kunta Kinte comme violateur de la Charte africaine et des instruments pertinents relatifs aux droits de l'homme. L'enjoindre à libérer les individus victimes de détention arbitraire et à condamner les auteurs des pratiques néfastes féminines en Bamileke. Ainsi sera justice.
Thank you, Counsel. Thank you very much to all counsel from both sides for their very interesting arguments and submissions delivered very eloquently by all sides. I'm sure that I speak on behalf of all my colleagues when I say we have been enriched by your submissions. It will be time now for the court to adjourn and go and deliberate. And unless the organizers indicate that there's anything else, and it looks like there isn't, the court adjourns.